Welcome. I am Dean Reuter, Senior Vice President and General Counsel of the Federalist Society. I'm very, very pleased to welcome all of you here today. Thank you for being here. And I want to take a brief opportunity, because I don't think I've done it publicly yet, to thank Reg Brown, the new-ish chapter president of the DC Lawyers chapter. So thank you, Reg. Also, I just wanted to provide a very small bit of context on today's event. In the 20 plus years of my tenure at the Federalist Society, we have covered a lot of territory in terms of topics and issues and policy and law. I never foresaw that we would have to be discussing civility in the law, civility in our profession, but here we are. So here we go. Several months ago, I was delighted to receive an invitation for a sit-down meeting with ABA President Deborah Enix-Ross, and equally delighted to learn that civility in the law was one of the major points of focus of her one-year tenure, that she had chosen to make that part of her focus. So this event is in part a product of that initial meeting, and we've had some other things going on as well. So I want to thank David Boies for being here with us today, and of course, our good friend Chuck Cooper for being here. Thanks again to Reg Brown for leading our discussion, and thanks to Deborah Enix-Ross, not just for being here today, but for reaching out in the first place. So off you go. Thank you very much, everyone.
Thank you, Dean, for making sure we always have a great lineup of events, and really looking forward to the discussion today. I guess, as you said, here we are and here we go. I'll give you a little bit more background on our speakers. Deborah Enix-Ross is currently the president of the ABA, the world's largest voluntary association of lawyers, judges, and other legal professionals. She's also a senior advisor at Deborah, Boies and Plimpton in New York, where she specializes in international dispute resolution, which may help explain her strong commitment to civility in our profession. Deborah is a graduate of the University of Miami School of Law and has completed further studies at Columbia University and the London School of Economics. Welcome, Deborah. Props to the 305 and the U of Miami football team, which most weeks I like. Our second speaker is Charles Chuck Cooper. He's the chairman and founding partner of Cooper Kirk. He is a longtime member of the Federalist Society. Chuck previously served in very senior roles at the Justice Department. You've been described, Chuck, in the press as a powerhouse attorney, a hard-nosed litigator, and this was my favorite, a Washington legal institution unto himself. I'm still trying to figure out if that's a compliment or not. Chuck has argued 9 cases before the Supreme Court. He's an extraordinary lawyer, previously clerk for Justice William Rehnquist. He is a graduate of the University of Alabama School of Law, which I will note is 15-3 against the University of Miami.
Oh, that's not very civil.
I just want to kind of get a little tension here to see whether we can keep things civil. David Boies, our third guest speaker, is the chairman and managing partner of Boies, Schiller, and Flexner. David was named Global International Litigator of the Year an unprecedented 7 times. He was also named by Time magazine as one of the 100 most influential people in the world. I don't know where you go for an encore after that. David is no stranger to Washington, having served as a leading staffer in the US Senate and a special trial counsel for the Department of Justice in the United States versus Microsoft case. He is a graduate of the Yale Law School and NYU Law, and he is a recipient of the ABA's highest honor, the ABA Medal. Yes. I was looking for something to say about football, and all I could think about at Yale is that they've been playing for a long time. So we're going to just dive.
We beat Harvard every now and then.
That's fair enough. Let's dive right in. And we'll go with first names for this, because we're civilized. Deborah, you made civility and collaboration a key priority focus for your tenure as head of the ABA. Why?
Well, first let me say thank you for the opportunity to be here and for the gracious way that I've been received and for the great conversations we had by Zoom. So hopefully we'll be able to portray that here in person. When I was thinking of running for ABA president, one reaction was, why would you do that? But putting that aside, I began to think about what would I want to focus on. And it was at the same time that I had a lot of my non-lawyer friends asking me questions that essentially boiled down to not understanding the rule of law. And I don't know about you as lawyers, but in my community, when you're a lawyer, people think you know all areas of the law. So they were asking me criminal law and landlord-tenant and eviction, and I was like, I'm not that kind of lawyer. But I understood the synthesis was rule of law. And it dawned on me that there was a lack of understanding of civics and civic engagement and civic education. Civility at the same time. People were not able to express their points of view without becoming overly aggressive and agitated. And then for me, I began to think this is a problem that is, although the rule of law is certainly the sweet spot for lawyers, it is not our exclusive opportunity, and nor should it be, and that we need to collaborate across the profession, but also across other stakeholders. So whether it's journalists or business leaders, faith leaders, all of us coming together. So those were the ideas that then became what we are now calling in the ABA the cornerstones of democracy, the 3 C's: civics, civility, and collaboration.
Well, that's terrific. You know, when you mentioned landlord, tenant, and traffic law, I kind of think that ought to be a class in law school, because everybody who's a lawyer gets asked by their family members,
yes.
And then you don't know the answer, and they're, what good are you? Chuck,
that's exactly what happens in my family.
Chuck, you are described by lots of folks as a hard-nosed litigator, but you've also earned a reputation as being a consummate gentleman, and you figured out a way to practice law in a particular way. And I was wondering if you could tell us, like, what was the mindset that lead you to practice law that way, and how widespread is your practice in terms of civility in the profession these days?
Well, thank you, Reggie. First, I want to thank FedSoc for putting on this panel and for inviting me to participate in it. I'm honored to be here with old friends, David, Boies, and Reg, and new friends, and
I'm glad you didn't call me old. Thank you.
and Deborah. And, you know, Reg, I think it really relates to how you were brought up. It relates to the lessons you learned along the way from the people who mentored you. Mm-hmm. I was mentored by a football coach who told us about, and he meant a lot to me, about character and principle, and always considering other people's views. I clerked for Judge Paul Roney in the old Fifth Circuit. He's a wonderful man, and Chief Justice, then Associate Justice Rehnquist. They really personified civility and professional courtesy, dignity, always treating with others in good faith and honorably. And I've thought that was always an indispensable ingredient, not just to being a professional who enjoys what he does or she does, but to success as a professional. I think that the costs of incivility, and sadly, we're having this panel discussion at a time when it needs to be had, but the costs are very high. I can't think of anything good that comes from incivility among adversaries in the law. And, on that score, just a personal reflection. I have to say that David Boies here is among my dearest friends. We come from very different political traditions. We hold some very differing, deeply held political values. But over the course of many years, we've become very dear friends. And it's been born of the adversary process, dating back to the mid-90s, when we spent several weeks in a courtroom together in a very contentious case dealing with a school desegregation decree that controlled Wilmington, Delaware. And then other conflicts along the way, but perhaps most prominently the California Proposition 8 gay marriage case, where we were zealously advancing the interests of our clients, to be sure, but in a way in which was marked by mutual respect, professional courtesy, good faith, and honorable dealings. And out of that, you find, comes professional admiration, and sometimes bonds of friendship can be forged, as they have in our case. And so it's a special joy for me to be addressing this subject matter with a nemesis of mine in the courtroom, but a dear friend out of it. Shakespeare in The Taming of the Shrew said, adversaries in law strive mightily, but then eat and drink as friends. And that's the way it can be. It's the way it should be. But it can't be that way absent the things that are encompassed in the idea of civility in the practice among adversaries.
That's a great observation, and knowing a little bit about David's wine collection, the idea of eating and drinking as friends seems very, very enticing. David, you have been in the middle of some of the most extraordinary legal controversies the world has ever seen. Reference one just a moment ago, which was around the marriage equality debate, where you paired up with Ted Olson, and your worthy adversary was Chuck. You were also deeply involved in Bush v. Gore and the like. Tell me about your views about civility in the law. Does it go beyond just good manners?
I think it does. One of the problems with following Chuck Cooper is he always says all the right things, and it is a challenge to go after him. I was on the same side as Ted Olson in the Proposition 8 case, but of course he was my adversary in Bush v. Gore. I have had the pleasure of being both opponents to and on the same side of both Chuck and Ted, and I can tell you that it's much more fun to be on their side than it is to be against them.
Amen.
I think civility goes way beyond good manners. It goes to the heart of what we are as a profession and what we need to be as a society. And Chuck talks about what we should be and what we can be. And when I started the profession, that's what we were. When I started, and you don't want to know how many years ago that was, lawyers with strongly held views and with clients who were often violently opposed to each other, nevertheless got together, were friends, were colleagues, and recognized that we play a part in the justice system. We are not the justice system. We are not our client. We are not the judge. We are advocates. Our goal is to present our client's view as zealously as we can within the bounds of the rules of our profession. And one of the things that you cannot help but admire in an opponent is when they do that well and they do that with integrity, where you can trust them, where you understand their arguments and you understand what their conscience is, what their character is. It was we've worked together, but the times when we've been apart, working on opposite sides, have been very contentious. The case in Wilmington was a very contentious case. We had clients on either side that were, felt very, very strongly about whether the schools should be freed from a desegregation order. When we walked out of the courtroom in the proposition case, our supporters on either side were outside yelling and screaming with placards.
Yes. There were more yelling at me than in San Francisco. I promise you that.
I had a lot of people telling me I was going to hell, and they meant it. But what's critical, I think, for our profession and our society is that we be able to communicate with people that are on the other side, and we be able to respect and be friends with people who have different views. As Chuck knows, I have my oldest son is considerably to the right of Chuck. Hard to believe. That is possible. Let me tell you, you may think that's not possible. But it's true. If you meet my son David. And I think that having somebody in the family with whom you have strongly held, very different views of society and of social issues, but who you love and who you respect. I think we all need to be able to love and respect people with whom we strongly disagree. And we need to be able to work with them on the issues where we don't disagree. Because there's almost always some common ground. And we've got to be able not to give up our principles, but we've got to be able to find that common ground. Because as Americans, we have really more in common than we do in differences. Those differences may be very violent and may be very important to us, but we share a common heritage. And we need to get back to those commonly held views, those commonly held character traits that we all respect. And that's not only important for us as a profession, but it's important for this country. And the legal profession needs to lead that. Because if lawyers can't get along, lawyers who are trained to be advocates, lawyers who are trained to see the other side, if we can't get along, nobody's going to get along.
Let me just press on that a little bit. A lot of matters now get resolved not just in the courtroom, but in the court of public opinion. And the case doesn't stop when you walk out of the courtroom onto the steps because the cameras are there and you're trying to persuade society because the decision might be made by the courts, it might be made in the legislature, it might be made in boardrooms and the like. If you're obligated to be a zealous advocate and denying respectability to your opponent might help you win by kind of making their views outside of the pale. Do you have an obligation to do that or not? I'll leave that to either of you, and then I'll come back to you on something else, Deborah.
Yeah.
Well, I do not believe a lawyer has that obligation. I believe a lawyer has the obligation to zealously represent the client's interests, but that doesn't include hating your opponent.
Yeah.
It doesn't include viewing your opponent or your adversary in the courtroom or your adversary's client as your enemy, as someone who's evil. It just means they see things differently from you. Their interests are in conflict with your client's interests. And it's your job to, I believe, civilly, respectfully, and honorably present your best possible cases as firmly and as persuasively as you can to the decision maker. Sometimes that means arguing that he's not the decision maker. That decision should be somewhere else. But David puts me in mind of when he references how we would enter the courthouse through a phalanx of people, who were very much invested on both sides of that issue. And I have grown accustomed to entering courthouses in that way, as I know you have too, David. I do remember, though, after the trial, and you learn a lot in a courtroom. You learn a lot about the people who you represent. You learn a lot about your opponent. You learn a lot about the interests and values of the clients that your opponent represents. But I remember remarking publicly that, and denying that I or any of my colleagues bore any ill will to David's clients in the Prop 8 case. And to the contrary, I sat in a courtroom with them. I heard their testimony. I watched them. I interacted with them some. And I remarked that I don't know, they seem like two of the nicest couples you'd ever want to meet. And I will tell you, I got some, you're going to hell, emails and hate mail from that. But no, that is not, in my opinion, the advocate's responsibility to his client. To the contrary, I think the advocate's responsibility is to try to educate the client that, no, there are lines I cannot cross, I will not cross in advocating your case. I think some of the pressures that lawyers come under, and Lord knows, especially these very, emotion-laden, passionate culture war issues, make it very difficult for the parties to remain civil. And that's true in the court, where you're already under enormous pressure as a lawyer, great stresses, you're going 24/7, it's easy to lose your temper. You've got to do your very best to discipline your emotions and always remain civil and respectful. And the truth is, if you don't, you're less effective. You're less effective.
Thanks. Deborah, you told me when we were sitting at lunch that you gave a graduation speech this past weekend. I am sure you were well received down in Miami, but that is not always the case for speakers. There was a recent episode at Stanford where a federal judge was effectively denied an opportunity to speak and be heard. There was pushback on the students that tried to deny him a forum from the dean of the school, and she read. She sent a letter around, which I thought was a great way to kind of keep the dialogue going in a constructive fashion. One of the things she read was Stanford's statement on academic freedom. It said that Stanford University's central functions of teaching, learning, research, and scholarship depend upon an atmosphere in which freedom of inquiry, thought, expression, publication, and peaceable assembly are given the fullest protection. Expression of the widest range of viewpoints should be encouraged, free from institutional orthodoxy and from internal or external coercion. If I put that up for a vote at the ABA today, would it pass?
Well, as a former chair of the House of Delegates of the ABA, the policy-making body, I think that it would be the subject of some really good debate. And I do think it would pass. I think that, the ABA is perceived to be very liberal, and I don't think that that is an accurate portrayal of our members. I think some of the issues that we address or that we have policy on, some will think of them as liberal issues, whether it's gun control, whether it is women's reproductive rights, voting. But for me, those are in the sweet spot of what we are meant to do as a profession and as a bar association. To have that kind of advocacy, to have that kind of debate, and then have a vote. So I think that it would pass. Interestingly for me, the ABA's most recent Civics survey, which has now a civility piece in it for the first time, 85% of the respondents said that civility is worse now than it was 10 years ago. When you dig in deeper and ask, so what are the causes? The number one answer is social media. The second is media in general. And then the third is our political leaders. And when you ask what some of the solutions are, and this goes back to you, I was thinking about you when I thought about the survey results, it says, family and friends are the first area where we can have civil conversations. And it is up to family and friends to be able to demonstrate how to have difficult conversations and do it in a way that's productive. So we know that there are the tools, we know what the problem is. I mean, as lawyers, we're really good at kind of identifying what's the problem. But now what are some of the solutions? So it's a long way of answering your question. I do think it would pass. And I think it's important for us as lawyers to be seen not only in this adversarial role, which is the one that most people think of when they think of lawyers, but also as leaders in the idea that we can have very heated conversations, very difficult conversations, but do it in a way that's productive.
David, curious about your thoughts about the judiciary and the current climate, around getting judges through. You were on the Senate Judiciary Committee staff as staff director for a while. The 93-0 votes for judges don't happen anymore. And I was wondering if you think that the current political environment is hurting the cause of civility in the law.
Well, I do. Let me just make a comment, though, on the Stanford policy. I think it might pass at the ABA, but I don't think it would pass from a vote of the Stanford Law School students. And I'm not sure it would pass with a vote of the Stanford faculty. And I think that is what is disturbing. It may be that the lawyers have an ability to recognize the value in free expression. And I'm old enough to have seen attacks on free expression come from both sides. And those attacks never end well, end well for anybody. But I think that you have a sense now among young people that somehow you need to suppress, that people on the other side are so bad that you need to suppress what they're going to say. And I think that so much undermines everything that protects our liberties in this country, that something has to be done about that. And I think the legal profession really needs to lead the way. And I think part of civility is recognizing that people have the right to say something and be treated civilly, even when they are saying things that you strongly disagree with. I think the confirmation process is toxic. I think we have stopped thinking about who is going to be a good judge in the non-controversial case, and are focusing on who is going to be a sure vote on the controversial case. And I think the confirmation process is now a series of litmus tests. What each side is doing is trying to figure out, A, who is going to be a sure vote today and who is going to stay a sure vote 10 or 20 years from now, and who is going to be young enough to stay on the court for a long time. We have so politicized the process that we are beginning to get the judiciary we deserve. And I think that the Chief Justice said a few years ago, there are no Biden, it wasn't Biden, it was no Obama judges, there are no Trump judges. We are risking a situation where we end up with Republican judges and Democratic judges. Increasingly, on controversial issues, you can predict how a judge is going to come out by who appointed that judge. That is different than it was in the past. Some of the most conservative judges ended up being appointed by some of the most liberal presidents, and vice versa. Felix Frankfurter was appointed by Franklin Roosevelt. Earl Warren was appointed by David Eisenhower. So the process has changed, and I think the process has changed in a way that tends to distort the judiciary and is harmful, not so much to civility, because I think by and large the judges are, more civil than the lawyers. Although I think even at the judiciary, I think civility has suffered. I think judges are less courteous to lawyers than they used to be. But predominantly, I think the problem is that we are so politicizing the judiciary that people are losing confidence in it. The number of people who say they have a great deal of confidence in the fairness of our judges is at an all-time low. And I think we're politicizing the prosecutorial. Chuck and I were talking about this last night. As Chuck knows, I'm no fan of Donald Trump. But the prosecution that's going on in New York today is something that I think gravely undermines the rule of law. It gravely undermines the confidence that we have in prosecutorial discretion. And I think it contributes to the kind of divisiveness that leads to incivility.
And can I just pick up on that?
Absolutely, pick on that. I'm very worried that
Not
that
pick on it, but pick up on it.
that David may not be able to eat and drink with some people in Washington after having said that. But Deborah, over to you.
Well, with his wine collection, I think he'll be okay. So we, just to underscore that, again, some of the surveys and the reflections that we've seen, that confidence in the judicial system and literally in the judicial process. We've asked questions, and the majority of the respondents believe that there's racial bias built into the judicial process. So I just want that to sink in. Like, they believe that it's built in. And it cuts across race, it cuts across age, but these statistics in particular were shocking to me. And that is that 63% of people between the ages of 18 and 36 believe that there's racial bias built into the system. That's our next generation. Those are the young people that we want to go into the law and become our prosecutors and public defenders and judges. And if they already believe that there's bias, what does that mean for confidence in the system, and what do they do when they have disputes? What do they say? It's not going to make a difference because there's already bias built in. Along racial lines, what we find is like 48% of white people believe that statement, that there's racial bias built in. 54% of Hispanic respondents believe it, and 75% of Black respondents believe that there's racial bias built into the system. Now, when I talk about that to my non-lawyer friends who are Black, they say, well, who are the 25% that don't believe that there's bias built in? But it goes to the point that that doesn't just go away. When people don't have confidence in our court systems, that undermines the rule of law, and they then seek other ways of expressing that. And so I think that's what you're seeing with some of the statistics about the lack of civility and people not really feeling heard. And that's why it's really important for us to be focused on that civility is not just about being nice or being polite, as you indicated in the beginning, and it doesn't mean that there's the absence of conflict. In fact, we know that in order to have a strong democracy, you need differing views and differing perspectives. We've just got to get back to being able to express ourselves and do it in a way that will be productive.
So, yes, and then I want to go to the audience. I think what Deborah said was that bias, or the perception of bias, is a root cause of incivility. Do you have a response to that?
Well, I have no reason to doubt that. I'm sure that that the resentments that are born of bias and perceived bias lead to the kind of conduct and actions that are not in the traditions of civility. But I want to, if I may, just also follow up on something David said, which is civility within the judiciary. I at least some of the things I see and I read suggest to me that there may not be the kind of collegial relationships within some collegial courts and multi-member courts that perhaps I witnessed when I was a law clerk in the old Fifth Circuit, which had 28 judges or something like that at the time, and where all of the judges, no matter what perspective they brought to their jobs, no matter who they were appointed by, were extremely collegial. I remember being a law clerk in the Supreme Court in OT 78 and walking down the hall one day, and out of the conference came the members of the court. They had just had a Wednesday or Friday conference, I don't remember, but Bill Rehnquist and Thurgood Marshall come out arm in arm, walking down the hall, laughing about something. The Scalia, Ruth Bader Ginsburg relationship, of course, is famous, and who could have been farther apart on the judicial spectrum. So, and the final point I'll make on that is that I have never been in a courtroom where I witnessed, and maybe my experience is unusual, but where I witnessed a lawyer being disrespectful to a judge. To the contrary, always deferential, and quite rightly so, and respectful. But I hate to say it, especially because there's some judges in the room here. I have seen, unfortunately, the opposite phenomenon. And I think we can all work to improve on civility in the courtroom.
If you all could think about, go ahead.
Well, only a twist on David's point about suppressing the unfortunate phenomenon we've seen about people want to suppress ideas and deny their legitimacy and brand them evil and not permit discourse about them. Sometimes civility requires you to suppress the truth, if you will. I'm reminded of the lawyer who had a reputation in his legal community for being quite cantankerous and difficult, and finally he retired from the practice, much to the relief of the local bar. But he got bored very quickly in retirement, and his wife was very tired of him hanging around the house, and so he decided he wanted to, go do something else, and he applied for a job as a greeter at the local department store, maybe a Walmart, Rachel, I don't remember. But in the interview with the HR lady, she asked all the usual questions, including, well, what do you think your greatest weakness is, Mr. Smith? He says, well, my greatest weakness, I'm certain, is I'm just too honest. And she says, well, I don't think honesty is a weakness. And he snapped, well, I don't give a damn what you think.
On that note.
Sometimes you have to suppress what you believe to be civil.
Why don't we go to the audience? Do we have any questions? While folks make their way to the mics, maybe you could hear from each of you what you think the best thing we could do to promote civility would be. Like, give me one thing, Deborah, that we could all do that would help us reverse this unfortunate trend.
So I would love to see civility go viral. And, I'm not of the TikTok generation, although we may all not be TikToking much longer. But to be able to demonstrate, to literally have the Scalia RBG kind of example and just have little clips, and you say, demonstrate, what does civility look like to you? And to be able to then have that as a national movement. Because I think lawyers are really bad at telling our own stories, right? We just are not really good at it. And it would be really important for us to show how you can be with someone who is your polar opposite, but find one thing that you have in common and have passion about, and start there.
It's a great place to start. We have a question. One of the mics?
Hey, Josh Blackman, South Texas College of Law, Houston. It's often said that certain issues are not up for debate. whether it's gay rights, LGBT issues, abortion, so on. People say to even deny this is to deny my existence. To even discuss this issue or refuse to say a certain word or pronoun is to deny your existence. How can you have a civil debate when the other side refuses to even engage on an issue, or are these issues simply beyond debate, that there's nothing to debate?
That's a hard question, so we'll go to David.
Thanks.
I think that it's important to understand that, and I think it's important that we all help each other understand that we can have very different views about people and very different views about social issues and still be part of the same society, the same community, where we need to cooperate and deal with each other with respect and love. We don't have to hate each other to disagree with each other. And I think that if you take the case that Chuck and I had in terms of Proposition 8, our clients were people who felt passionately that they had the right to get married, and that the laws that prevented that diminished them as human beings. They recognized, though, and I think this was partly Chuck's character that came through in the courtroom. I think it was partly the way Chuck treated them in the courtroom. I think it was partly the way Ted and I dealt with it. But they did not harbor ill will towards Chuck. They realized he was performing a role, just like Ted and I were performing a role in the justice system. We were advocates for a particular position, and that people on the other side might have very different views, and they might be views that our clients really hated. But that didn't mean they had to hate the people that had those views. And I think we need to, and to go to the question, what can we do about it? I don't think there's one magic bullet. I think it is a series of individual actions where we all try to treat people with civility. We all try to deal with the merits of arguments and not attack the personalities of the people on the other side. And where organizations, whether it's the ABA or the Federalist Society or any other organization of lawyers, tries to tell its members and tell the profession as a whole, this is not acceptable behavior. That we need to be able to respect people, even though we disagree with what they're saying. When I was on the chief counsel of the Senate Judiciary Committee, the chairman, when I got down there, I wasn't chief counsel because it was Jim Eastland, and I was working with Ted Kennedy. But while I was down there, Eastland resigned, Kennedy became chairman, and Strom Thurmond was the ranking Republican member. Kennedy could not have been more at odds with Thurmond and Eastland on most issues. But when Eastland retired, he called Ted and myself into his chambers with his chief counsel and said, just tell me what I can do to help in the transition. When Kennedy became chairman in the spring, he would have Thurmond and his chief counsel over to his house. In the fall, Thurmond would have Ted and myself over to his house to just talk at a social environment. People respected each other, and they believed that we were all part of the American system, and that was more, we had more in common than we had in differences. And I think we've got to get back to that. And I think it's people, you know, what I would say to somebody, you know, who says that is, I understand your point of view, and I might even share that point of view. But that doesn't make the person on the other side an evil person. It doesn't make them a bad person.
Thank you.
And I would add, you know what, here's a hashtag then. Civility is a choice. And we should always strive to choose civility.
Absolutely. And just to follow up on that, we should always strive to. I don't think any of us can claim never to have failed to live up to that standard. I know I can't. I wish I could. I do strive. I'm conscious about it. But as I was reflecting a few moments ago, in, the third week of a trial where you've, been working 24/7 around the clock, dealing with difficult witnesses and blah, 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 sometimes you slip. Either sometimes with your colleagues, sometimes with your opponents.
I was going to say civility with your colleagues at that point.
Yes, that's true. It helps to be the boss if that's the case. But you can fail, and we all have to recognize that. And I don't think there's anything more potent, Reg, to promoting civility is the power of apology.
Yes.
The power of apology. When the next day and things have calmed down, or the phone call that you had with the lawyer on the other side and it got hot, and you just say, look, I've been thinking about that. I was out of line. I apologize for that. Mm-hmm. I regret it. Yeah. There's nothing that helps to, I think, promote respect and civility than the power of apology and that's harder, really, than anything. But if you do it, I promise you it works.
Some terrific ideas. I hope that this YouTube video goes viral when we're done.
Civility is a choice.
Here, civility being a choice is a great theme. One more question, and that's sort of the role of the bar as an authority source, right? So we've talked about suasion, and your presence here today, I think, reflects really positively on that. But the bar has the ability to discipline its members. Law firms can decide who they want to hire. What are the sticks, if any, that could be used to promote civility, or is that just counterproductive?
No, I mean, I think certainly as lawyers, we have codes of conduct and codes of ethics. And of course, in the ABA, what we do is have model codes that then the states adopt. So as I had to explain again to my non-lawyer friends, the ABA can't throw out certain people, high-profile names of lawyers. It's not what we do. They will be dealt with in a disciplinary way by their respective state entities. But what we can do are things just like this, where we can agree as bar associations to be able to then demonstrate that. And one of the things I'm most proud about within the ABA this year, when we had this Cornerstones of Democracy project, is that we got a grant to then be able to help other bar associations, state and local bar associations, promote these efforts. And to me, that's going to be where it begins. It's a grassroots, it's coming up in our communities. But we know that as lawyers, we're the profession that people love to hate until they need us, and then they really want you to be whatever the analogy is, a pit bull or whatever it might be, especially in litigation. And that's a teachable moment for us. And we need to always keep that in mind. What we do matters. People look to us. They respect us as a profession. And we are part of a profession, and we need to make sure that in everything we do, we exemplify the best of the profession.
Reg, One thing that young lawyers, young law students need to understand, especially now, is that there's very little that is said or done anymore that isn't on some permanent record. Whether that record is an electronic message or a videotape held up from somebody's iPhone. We have seen some of the consequences that may flow from the Stanford incident. Those students who behaved so appallingly to Judge Duncan. We know that there are going to be some clerkship potential opportunities not available to them. I would imagine that there are going to be some employment opportunities not available to them because of their behavior, unless of course they mature and renounce, I think, the incivility of those episodes. There will be possible, seeing those videos in a confirmation hearing 20 years from now is inevitable if any of them aspire to public office. So civility is the smart way to live your life, even if not necessarily the way you want to at the moment. Right.
We'll dust this off in 20 years at the confirmation hearing. I want to thank the audience for being here today. I hope you all learned as much from this as I did. David, we're going to give you the last word. So anything you'd want to say in summation to Deborah and Chuck?
I don't have anything really to add. I think this is just such a terribly important thing for our profession, for the justice system, and for our country. We've got to get back to the point where we can cooperate even with people that we strongly disagree with. We've got to be able to find the common ground that we have. And even when we can't find common ground, we've got to respect the person that we're dealing with, and we've got to demand that from other people. My favorite television ad is the ad that ends with "Jesus loves the people you hate." Mm-hmm. I think that I think we need to remember that we all of us, each of us, no matter how much we disagree with the other, we're each a child of God, and that we each need to respect and, to the extent we can, love the people that we disagree with.
That's terrific. Well, thank you all. Really appreciate you being here today.